spent for the general welfare and to provide for the national defense. And then there's the regulatory power. So just with respect to the spending power, you already heard about the South Dakota versus Dole case. With respect to the spending power has been interpreted, and actually has been interpreted for a very long time, as being a very broad discretionary power on the part of Congress. And what's really responsible for the huge growth of federal power under the spending power isn't the spending power itself, it's the 16th Amendment income tax amendment, which is part of the actual written Constitution. It was ratified the correct way. And what that's done is created an enormous amount of tax power, an enormous amount of tax revenue that Congress can spend. If you can imagine the federal government without the income tax amendment, without the income tax, you would see that sort of having a discretionary spending power would not be such a big problem. But because the Constitution has already been changed to provide a real engine of taxes and revenue to the federal government, now the spending power and placing conditions on spending is a major way that the federal government has expanded its power. Now what about the regulatory side? How has that happened? Well, you all know, most of you know, that it's been done under the rubric of the Commerce Clause, which gives Congress the power to regulate commerce with foreign nations and among the several states and with Indian tribes. But it hasn't actually been done unless you've gone to law school, they've told you otherwise. But it actually hasn't been done by expanding the original meaning of the Commerce Clause, which really, the original meaning of commerce was the trade that would take place between individual people or between one state and another state. It referred to trade. It did not refer to the productive activities of agriculture or manufacturing that produced articles that would then go into commerce. That's what commerce meant. But that's not what the Supreme Court never expanded the meaning of the word commerce. What they said is, under another enumerated power, the Necessary and Proper Clause, that Congress may regulate a whole bunch of stuff that isn't really commerce itself. And the Necessary and Proper Clause gives Congress the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers elsewhere in the Constitution. This was sometimes referred to the founders as the sweeping clause, because it would sweep all power into the federal government. So you can see the problem here. Under the 10th Amendment, you look to the enumerated powers. When you look to the enumerated powers, you combine the commerce power with the Necessary and Proper Clause, and then what you have is an almost unlimited regulatory power in Congress. When you couple that with the spending power, that's the problem we have today. And it's no accident that the Tea Party has basically two major things that they object to. It's spending and debt, and it's expansive congressional regulatory power. The two things I've just talked about are what that political movement is about. All right, now what can you do about it? Well, there's a number of things. You heard about the interstate compact idea. It sounds like a good idea to me. I would caution you only that one cautionary question you already had is it hasn't been litigated when states are really doing something adversarial to the federal government. Courts are very clever and very creative at allowing federal government to trump state power. So that's going to happen in the courts eventually. And I would push this. But I would just, it's not a magic wand. It's not a silver bullet. You've already heard that. Nothing is. But there's another power in the Constitution you've already heard a little bit about. I'm going to tell you a teeny bit about it, and I'll talk about why you think you should use it in a particular way. And that is Article 5's amendments power. This is a power that the Constitution gave state legislators, not the states. If it gave it to the states, the governor's involved. It gave it to state legislatures. State legislatures can resolve and apply for a convention for purposes of proposing amendments. Everybody calls this a constitutional convention. Unfortunately, even in the material that's been handed out to you today, it's referred to as a constitutional convention. Article 5 doesn't call it a constitutional convention. It says it's a convention for proposing an amendment. The best way of describing it is it's an amendments convention. And calling it that immediately says what it's limited to. It's limited to proposing amendments to the Constitution. If 2/3 of the states call for an amendments convention to propose a particular amendment, then Congress is supposed to, shall call that convention to deal with whatever it was that the states asked for. That's a power that was given to the states. It's not a symbolic power like a state sovereignty resolution that you may pass, which, by the way, is not a bad idea to pass, but it doesn't have a legally binding effect. It is a constitutional power that's contained in Article 5. And because it's a real power, it's a dangerous power. All powers are dangerous. And for that reason, if you try to exercise that power, you are going to get pushback. And you're not going to get pushback from the left. You're going to get pushback from the right. You're going to get pushback from the Eagle Forum, Phyllis Schlafly. If you haven't already known that name, if you don't know that name yet, you will know that name soon. You'll get pushback from the Heritage Foundation here inside the Beltway. You'll get pushback if you try to use that power because people are afraid about what would happen if you had an amendments convention. It's threatening. It's menacing to some people. And many of your constituents will also be afraid. They've been made afraid, by the way. So a campaign to make them afraid. You know something else that people are afraid of? They're afraid of guns. There's a lot of people who are in this country who are afraid of guns. You know, because why are they afraid of guns? Because guns are dangerous. Guns can be abused. Guns can hurt people. How many of you know something about the Second Amendment and support the Second Amendment here? Well, the Second Amendment basically says that the people have a right to this dangerous instrumentality in order to use their own best judgment in order to protect themselves when things go awry, either personally or collectively, for personal or collective self-defense. Well, the Article 5 convention process is like a gun in the Constitution. It's a loaded gun in the Constitution put in the hands of state legislators to use for good and to use for ill. Now the question you have to ask yourself is, are we living in a really happy, tranquil time where everything's going pretty well and we don't want to rock the boat, and therefore we don't want to pick up our guns, we want to keep them locked in the drawer because it's not time? Or are we living in a different time in which the federal government is coming at us with its constitutional powers as been interpreted by the Supreme Court, and it's time to open up the drawer in which our Article 5 powers are as state legislators, and take that out and start brandishing it to try to ward off the attack of the people that are trying to break into your homes. I think that time is now. It's not because anybody who brandishes a gun wants to shoot the intruder. It's because you have no choice, and now it's time. So that's what an Article 5 convention is. That's why I think you should use it. You're going to be threatened. You know, people are going to use scare tactics about using it, but it's within your power to do it. It's within your power to do it responsibly. And we can go into details later, but I only have, you know, a few short minutes. So now I want to talk about one of the things, and that's the way I would think about it. And when people have started using why it's scary, why it's awful. Yeah, it's scary, it's awful. So are firearms, but they are necessary. And this one happens to be necessary, and the founders put it there for this day. And now it's up to you as state legislators to use the power it put in the hands of state legislatures. Okay, now, there are various ideas about what to use this power for. I'm just going to talk about one of them. It's the one I've been pretty closely associated with. It's called the Repeal Amendment. And you all have a handout here which describes to you what the Repeal Amendment is. And one of the beauties of the Repeal Amendment is that it's so easy to describe. It's less than 100 words. I'm not even going to read you the amendment. I'm going to tell you what it says. The amendment says that if this amendment is passed, 2/3 of the state legislatures can repeal any federal law or regulation. That's it. That's the amendment. If the amendment is adopted and added to the Constitution as the 28th Amendment, it would take 2/3 of the legislatures of the states, not the governor, the legislatures of the states, to repeal any federal law or regulation. What this does is restore the original balance between the states and the federal government in the face of this huge expansion of federal power that is not going to be rolled back in the courts. Not going to be rolled back in the courts overnight, that's for sure. And the way it does that is not by adding another thou shalt not. Congress shall make no law with respect to X in the Constitution, because if you say that, Congress shall not do this, Congress shall do that, then ultimately that's got to be regulated. That's got to be litigated in the courts. When Congress refuses to do it, then you got to go to the court and sue Congress, and then what have the courts done? They've already undone all the parts of the written Constitution that constrain Congress's power now, like how about that provision in the Constitution that says revenue bills must originate in the House? And yet in the health care debate, we passed the Senate bill. What was that all about? Well, what that was all about is that they have bills that shell bills, they strip out of all the language, sent over from the House, they strip it out. That Senate bill is an amendment to a House bill sent over there, and then that's how it's a House-originated bill. It's a game. It's a game, but the courts won't scrutinize that. The courts won't hold Congress accountable for that. Therefore, that part of the Constitution's gone. What this repeal amendment is, it's a structural check that does not require the courts to intervene. It puts the power of repeal in the hands of state legislators directly. And structural checks are what James Madison and the founders were all about. Checks and balances. And that's what this is. It's another check and balance. So what I'm basically suggesting to you is that you use the power that is in the Constitution that's given to you to use, and that is the power to call for an amendments convention under Article 5, and